Ipob takes battle against proscription to Supreme Court. Good morning, everyone, and thank you for tuning in and listening to this channel that we got to this morning. As our headline for this morning says that Ipob takes battle against proscription to Supreme Court. Well, a group filed a 5-ground notice of appeal to the effect on February 7 through its lawyer Aloy Ejimakor. It has the Attorney General of the Federation (AGF) listed as the sole respondent. The indigenous people of Biafra (Ipob) has gone before the Supreme Court of Nigeria to challenge the January 30th judgment by the Court of Appeal, Abuja, affirming its designation as a terrorist group and proscription by the federal government. The group filed a 5-ground notice of appeal to that effect on February 7 through its lawyer Aloy Ejimakor. It has the Attorney General of Federation (AGF) listed as the sole respondent. Ipob is contending, among others, that its proscription violated constitutional provision, particularly the right to fair hearing as enshrined in Section 36 of the Constitution. It faulted the Court of Appeal, arguing that the lower court erred in law in upholding an ex parte order that led to its designation as a terrorist organization, without affording it the opportunity to be heard. Ipob said that the Court of Appeal misinterpreted the Constitution by prioritizing national security concern over its right to a fair hearing. The group added that the proceeding leading to its prosecution failed to meet the standard of proof required in criminal cases before allegation of terrorism required proof beyond reasonable doubt. Ipob is also contending that its classification as a terrorist group unfairly subjected its members, who are primarily of Igbo ethnic origin, to discrimination contrary to Section 42nd of the Constitution. It added that the Court of Appeal wrongly equated proceedings before a judge in chambers with an ex parte hearing, thereby denying Ipob the right to present the case. Ipob further faulted the Court of Appeals, claiming it exceeded its jurisdiction by effectively declaring a state of emergency, a power Constitution reversed for the President under Section 305 of the Constitution. Citing the African Charter on Human and People's Rights, which it claims guarantees the right to self-determination, Ipob argued that its agitation for the state of Biafra falls within the legal boundaries of international human rights law. The Court of Appeal had, in an anonymous of a 3-member panel on January 3rd judgment, upheld the argument by the lawyer of the federal government, owing that the state acted lawyer in prescribing Ipob, whose activity it held threatens the nation's continued existence and the security of citizens. Well, in the lead judgment, Justice Hama Baka resolved all the issues raised for determination against the appellant. Ipob declared the appeal meritorious and dismissed it. He faulted the claim by the appellant, Ipob, represented by Shukuma Ume, so that the procedure adopted by the federal government in proceeding the group was flawed. Justice Baka held that the federal government fully complied with the provision of the relevant laws, particularly Section 2 of the Terrorism Prevention Act, by adopting the ex parte proceedings. He said such ex parte proceeding, unless tainted, does not constitute any breach of the right to fair hearing of parties before the court. Justice Baka adopted the position of the Supreme Court in the case of the Kombo Asari against the Federal Republic of Nigeria, to the effect that when national security is threatened, or there is a likelihood of being threatened, human rights or individual rights or those responsible takes a second place. He added, human rights or individual rights must be suspended until national security can be protected or well taken care of. This is not anything new. The corporate existence of Nigeria's united, harmonious, indivisible, and undisclosable sovereign nation is certainly greater than any citizen's liberty or right. While the security of this nation is in jeopardy and it survives in peace rather than in peace, and it survives in pieces rather than in peace, individuals' liberty or rights cannot exist. Justice Barker said, while the claim by the appellant lawyer that the founder of the group had good ideas to achieve could be possible. There is no doubt that Ipob, based on its activities, was infiltrated by Hoodlum, operating and surviving on mayhem, which is the worrisome and quite evident to all well-meaning Nigerians. And that was what I was said here concerning this headline today this morning, which says here that Ipob takes battle against its prescription to the Supreme Court. And well, of course, you're ready for me this morning. And if you're not a subscriber, the best you can do right here, right now, is to tap that subscribe button with the notification bell so that anytime I have any new video, you will first get notified about it ASAP. Ipob takes battle against prescription to the Supreme Court. Wow. The indigenous people of Biafra, yes, We all know of recently the federal government labeled them and captioned them a terrorist organization, and they don't like that fact at all. That the federal government labeled them as a terrorist organization. They don't like it. Who likes it? Who likes being labeled as a terrorist? Nobody likes it. Good. Well, they went to the court to sue the federal government for what they did. Yes, because they see that this is wrong. And I myself, I feel that also this is wrong. You cannot just label Ipob as a terrorist group. Ipob has not done anything to deserve that caption, terrorist organization. Ipob has not done anything. They've never killed anybody. They've not done, and they keep saying it, that all the insecurities that is happening in the southeastern part of the country, they're not the fault. It's not their fault. They don't have anything to do with the insecurity in the southeastern part of the country. They keep saying it, but the federal government, no. They don't just listen to them at all. I'm telling you, the federal government don't just listen to Ipob at all. They keep labeling them as terrorist organization. And now, Nnamdi Kanu was so angry, seeing all these terrorists, everything. He sued. Then he went to the Supreme Court to nullify that saying that IPOB is a terrorist organization. And what did the Supreme Court do to Nnamdi Kanu? It was shocking. It shocked everybody too. The Supreme Court labeled Nnamdi Kanu and his group terrorist and terrorist organization. I mean, it shocked everybody. I'm telling you, it's the same way it's shocking, the same way it shocked me. It shocked everybody. Yes. Yes, and a lot of Biafran had a lot of things to say, because people are like, that is just wrong. How have you just call them terrorists? Have you seen them kill people before? Have you seen them do this before? Have you seen them do that before? I mean, of course, yes. The Nigerian government have to answer. Have you seen the indigenous people of Biafra killed people before? But all these Fulani headsmen that are but are everywhere, you guys don't call them terrorist organization. No, you leave them alone. Let them do their own thing. But a group just like the indigenous people of Biafra, you label them terrorist organization. That is so interesting. People who have actually killed people, the Fulani headsmen, you didn't call them terrorists. But people who are advocating with their mouth for self determination, you're calling them terrorists. Wow. Wow. Only God is says this Nigerian judiciary. What do you guys think? Drop your comments in the comment section. Don't forget to leave a like on this video. Then tap the subscribe button as we go on with the notification bell, so anytime I have any new video, you'll be the first to get notified about it. Once again, thank you for tuning in and have a wonderful day ahead of you.